His Excellency Mr. Daouda Jallow, I now invite Professor Philippe Sands to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honour to appear before you on behalf of the Gambia in respect of this application under the 1948 Genocide Convention. The importance of this case in relation to the protection of the Rohingya community in Myanmar and more broadly, and the importance of the issues before you at a time when the international rule of law is under grave threat are plain. This morning, I'm going to address the beating heart of this case, the meaning and effect of the Genocide Convention. How the court approaches this will determine how the Gambia's application is decided. And as you well know, the Convention is of singular importance in the history of modern international law. Adopted in 1948, very largely as a result of the efforts of one man, Raphael Lemkin, it was the first modern human rights treaty to be adopted after the horrors of the Second World War. It is emblematic. It is emblematic of who we are, of who we wish to be, of how truth and law are to address matters of raw power. If the Convention is diminished, then we are diminished, and the values that were articulated in that extraordinary post-war moment are diminished. The protections provided by the 1948 Convention have been addressed by this court on several occasions. These previous judgments inform how it is to be applied in the case of the Rohingya, and my colleagues and I will draw on these sources, guided by the rulings of this court, as well as judgments in genocide cases before other international tribunals and increasingly before national courts, in respect of the points that I make in this submission. Mr. President, it's to be emphasized from the outset that there are many aspects of the legal framework which are not in dispute between the parties. Myanmar and the Gambia agree on certain aspects and what the Convention says about them, but there are important areas of disagreement. And in respect of these areas of disagreement, the Gambia and all 11 of the intervening states speak with one voice on how the Convention is to be understood, consistent with the history, the context, the object and purpose of the Convention, as this court has interpreted and applied it. That united interpretation is, we say, important, for it highlights that where Myanmar's interpretation diverges, as it often does, it is a solitary expression of dissent. I'm going to proceed this morning as follows. First, I'm going to address the context and negotiating history of the Genocide Convention. Second, I'm going to identify key aspects of subsequent practice under the Convention, which elucidates the approach we invite the court to take. Third, I'm going to set out the significant points of agreement between the parties and the interveners on key provisions of the Convention. Fourth, I'm going to address the key components of genocide, namely the relevant actus reus and mens rea. And fifth, and finally, I'm going to address other aspects of the legal framework to be addressed by my colleagues in due course over the next 4 days. Start with the context, the negotiation of the Convention. Mr. President, Raphael Lemkin invented the word genocide. He constructed that word out of the Latin and Greek words genus and genocide, to mean the killing of a group or of a people. And here you can see the word in his own writing on the screen, a document that may be found in the rare book and manuscript library at Columbia University in New York City. He chose the word genocide as the title for Chapter 9 of his book, Axis Rule, which was published in November 1944. I've taken the liberty of bringing a copy of the first edition of that book, my own copy, to court today. As you'll see, it is personally inscribed by Raphael Lemkin in the Nuremberg courtroom on the 4th of July 1946. This room today is in direct connection with courtroom 600 and the Palace of Justice. And I invite you, please, to read all of Chapter 9 of that book. It's not long. It's available online. As you read Lemkin's words, I suspect, like me, you may be struck by two things. First, the convergence of Lemkin's account of the indicators of genocide that he found in the 1930s and the 1940s with the evidence that is before you in this case. And second, that the approach taken by Raphael Lemkin is fully consistent with the approach taken by this court in its jurisprudence. As you will know, despite the crime being argued before them, the judges at Nuremberg failed to mention the word genocide at all in the 1946 judgment. And this is what prompted Raphael Lemkin to engage in efforts elsewhere, leading up to the first ever session of the United Nations General Assembly, and ultimately his efforts bore fruit in December 1948. You, the judges of this court, need no reminder of the horrors which preceded and precipitated the formulation and adoption of the Genocide Convention, and which led states parties, including so many of the countries which you are each from, to heed Lemkin's exhortation to bring an end to the odious scourge of genocide. It was an imperative task in 1948, as the crime of genocide took its place alongside war crimes and crimes against humanity. And to be clear, while international law treats these crimes as distinct, it does not establish a hierarchy among them. Sadly, the task of 1948 remains as imperative today as it did then. Now, there's one aspect of the negotiating process to which I wish to draw the court's attention. Myanmar suggests that its crimes against the Rohingya, and they are crimes, cannot be characterized as genocide. Why? Because simply too few Rohingya were subjected to abusive acts. The argument is fallacious, as we will show in the coming days. But in this respect, the negotiation process of the Convention is important, as with Raphael Lemkin's intentions, because it makes clear that the crime of genocide is not a numbers game. The negotiating process involved 3 drafts, and in reaching agreement on the third and final draft, there the negotiators addressed the scale of destruction necessary to constitute the crime of genocide. The negotiating committee recognized that the Convention should include as instances of genocide such crimes as group massacres or individual executions on the grounds of race, nationality, or religion. France's delegate promoted this position, allowing that even a single death could constitute genocide. That is the approach enshrined in the Convention's wording, that there must be an intent to destroy the group in whole or in part. Of course, in this case, terribly, there is not just a single death. There are thousands of deaths and tens and hundreds of thousands of other genocidal acts, with upwards of 1 million human beings today in Cox's Bazar. Pause for a moment and reflect on that number. Over 1 million people. But let us not forget that the words "in part" were explained by Mr. Rafat, who served on Egypt's delegation, as being intended to achieve the aim of the French amendment. I turn to subsequent practice. This court's first interpretation of the Genocide Convention came not long after its adoption, the famous 1951 advisory opinion. And there the court recognized and underscored the Convention's purpose, a purely humanitarian and civilizing purpose. The high ideals which inspired the Convention, the court said, provide, by virtue of the common will of the parties, the foundation and measure of all its provisions. And so it is today. That purpose and those ideals inform the way in which the court interprets and applies the provisions of the conventions in this case. The court's jurisprudence on the convention, in particular with the Bosnia and Croatia judgments of 2007 and 2015 respectively, is the lodestar on which the Gambia's application has been based. Other aids to interpretation, including the jurisprudence of the international criminal tribunals and national courts, and it is worth mentioning that in particular it is the courts of Germany that have in recent years played the leading role in relation to rulings, judgments of genocide perpetrated in northern Iraq and Syria, including against the Yazidi population, as well as the findings of international commissions which provide guidance on issues arising under the Convention, as the interveners have made clear. But it is the court's own jurisprudence, your jurisprudence, that has played a central role in guiding the Gambia's approach, and we've fully relied on that jurisprudence in the decision of the Gambia to bring the case and in arguing the case in our written pleadings and in the course of these oral hearings. That approach of the court informs the views of all the interveners and the Gambia in these proceedings. And both parties and all the interveners agree on the basic and foundational principle articulated with force by the court in the Bosnia judgment, that a state is prohibited from committing genocide and a state may be held internationally responsible for the crime of genocide. And we note and agree with the Democratic Republic of Congo's very helpful summary of certain additional significant points of agreement. The DRC's submissions include the following. First, that a situation of armed conflict does not preclude the crime of genocide. Second, the Convention does not require that a genocidal intent be the sole motive pursued by a respondent state or its agents, but it permits of multiple and overlapping motives. Third, a genocidal intent does not have to be expressly stated and may be established or inferred either from particular circumstances or a pattern of behaviour or conduct. And fourth, the requirement that a substantial part of the protected group is targeted does not refer to a purely quantitative criterion, but is to be interpreted in the light of quantitative, qualitative, and geographic factors. These are very important points of consensus on the basis of which we say the court can proceed. I turn now to the definition of genocide, the famous Article 2 of the 1948 Convention. This provides as follows. In the present Convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. The 5 acts that follow in the text of Article 2 are A. Killing, B, causing serious bodily or mental harm. C, deliberately inflicting conditions of life calculated to bring about the group's physical destruction in whole or in part. D, imposing measures intended to prevent births. And E, forcibly transferring children to another group. Any one of these acts committed with the requisite intent is sufficient to constitute the act and the crime of genocide. And my colleagues will take you to evidence over the course of this week which will show many acts falling within the first four categories of Article 2 having been committed by Myanmar against the Rohingya group. In the counter-memorial, Myanmar argues that the number of victims is relevant to the determination of whether the actus reus of genocide has been committed. This is wrong. It makes this argument specifically in relation to the actus reus of killing under Article 2A, and Myanmar invites the court to conclude that unless killings are, and I quote, part of a campaign committed on a scale that is capable of bringing about the physical destruction of the relevant group or part of the group, they will be inadequate to constitute the actus reus of the crime of deliberate destruction of a human group. You can read that at paragraph 4.61 of the counter-memorial. Pure invention. There is no basis in the text of the Convention or the jurisprudence of the Court, or as I've already explained, in the negotiating history of the Convention to support this erroneous claim in respect of the actus reus under Article 2A. To the extent that numbers may ever be relevant, it's a factor that goes not to actus reus, but potentially to the question of whether the mens rea of genocide has been made out. This is because it may, not necessarily, it may bear on whether there is a reasonable inference that acts were carried out with the specific intent to destroy the group. That aspect of establishing the existence of the mens rea of genocide is a point to which I will return on Wednesday, to be followed by Mr. Reichler. But to be clear, there is no numeric or substantiality threshold inherent in the actus reus. As this court has observed, and the chapeau of Article 2 makes plain, there are, and I quote, two constituent elements, end of quote, to genocide, the mens rea and the actus reus. And whilst both must coexist for genocide to have been committed, they are, and I quote your words, analytically distinct, end of quote. The issue of numbers or the existence of concerted plans plays no part in establishing actus reus. And I also wish to underscore that killings under Article 2A are only one of 5 possible genocidal acts, 4 of which have plainly been established in the evidence that is before you. The Gambia does not contend that acts within the scope of Article 2E, that's to say forcibly transferring children out of the group, took place. But acts in all 4 other categories of Article 2 have been committed. And as the 6 joint interveners have underscored, and I quote, there is no hierarchy among the underlying acts of genocide, and the legal relevance of all acts targeting a protected group must be emphasized, end of quote. Thus, although terrible killings undoubtedly have occurred in this appalling case, it has to be underscored that the other modalities of the actus reus are just as central to the Gambia's case as acts of killing. Prominent in this case are acts falling within the scope of Article 2, paragraph B, causing serious bodily or mental harm to members of the group. The kinds of acts falling with this category are sadly diverse in this case. They include acts of sexual and gender-based violence, acts causing physical and psychological harm, and acts of forced displacement. And you're going to hear a lot more from this from the witnesses. next week. I make two particular points in this regard. First, Myanmar's campaign against the Rohingya is appallingly characterized by widespread sexual and gender-based violence. As the joint interveners have submitted, and as the Gambia has also affirmed, the harm caused by such acts is by its very nature and effect almost universally serious. This has been recognized by this court in the Bosnia judgment, which endorsed the vital findings of the Rwanda tribunal in the Akayesu case. And that case made clear that the effect of rape and sexual violence are one of the worst ways of inflicting harm on the victim as he or she suffers both bodily and mental harm. End of quote. These are genocidal acts. They fall within the scope of Article 2, paragraph B, all the more so where, as in the present case, children are involved, a point that is made with force by the interveners. They may also constitute actus reus under Article 2C and 2D. Very frankly, the evidence you're going to hear about this week is dreadful, and it's going to be very tough to listen to some of it. But listen to it we all must, and draw the necessary conclusions from it. We say you must. Second, forced displacement. The permanent expulsion of a people from their homeland is plainly capable of causing serious mental harm to members of the group, alongside any physical harm suffered in the course of their expulsion or which contributed to their fleeing their homes. In this case, it affects not only hundreds of thousands and upwards of 1 million human beings, but it's recognized, expulsion is recognized by the ICTY as capable of being a genocidal act. And let's be clear, expulsions do not have to result from the formal removal of people by bureaucratic state processes or the use of Auschwitz-style cattle cars. Expulsion arises in this case after the ransacking of villages, the burning of houses, the constant threat of violence against all who remain. It is these acts that contribute to the forced displacement that forms the actus reus within Article 2, paragraph B. And as the International Residual Mechanism for Criminal Tribunals has made clear, forced displacements do not always require physical force. They can, and I quote, be met through the threat of force or coercion, such as that caused by fear of violence, duress, detention, psychological oppression, or abuse of power, or taking advantage of a coercive environment. It is the absence of genuine choice that makes the displacement unlawful. End of quote. And this is exactly what has happened in the present case, along with the use of physical force, causing grave harms to the Rohingya within the meaning of Article 2, paragraph B. Such displacements may also be genocidal actus reus within the terms of Article 2C, as the court recognized in the Bosnia case. This point has also been widely recognized by international criminal tribunals in genocide cases. For example, in the Ptolemyer case, the Yugoslav tribunal held that underlying acts of genocide may include, and I quote, methods of destruction that do not immediately kill members of the group, but ultimately seek their physical destruction by systematically expelling members of the group from their homes. End of quote. I turn now to the second constituent element of genocide, namely the mens rea. This is a subject that has received a lot of attention, and not just from lawyers. Writers, journalists, psychiatrists, psychoanalysts, psychologists have all turned their mind to the key point, the question of intent. Now, I note, before turning to the dolus specialis of genocide, that each of the underlying actus reus acts have their own mens rea, which must be present in the perpetrator when the act is done. As this court explained in the Bosnia judgment, and I quote, "Killing must be intentional, as must causing serious bodily or mental harm. Mental elements are made explicit in paragraphs C and D of Article 2 by the words deliberately and intended, quite apart from the implication of the words inflicting and imposing. The acts, in the words of the International Law Commission, are by their very nature conscious, intentional, or volitional acts." End of quote. And so, for the actus reus to be present, the relevant acts must have been committed with the requisite volitional mindset. In most cases, it's going to be straightforward to establish that an act is intentional, as we say it is in this case. But, alongside this aspect, and as an essential ingredient in genocide, is the existence of what has been called a dolus specialis. The intent must be to destroy in whole or in part a national, ethnical, racial or religious group, and to do so as such. Now let's turn first to the first part of this totemic chapeau, the fundamental basis of genocide, the core feature of the crime, what distinguishes it from other crimes, is that it is predicated on establishing an intention to destroy. The intention, however it is expressed, must be to achieve the physical or biological destruction of the group in whole or in part. Although the extent to which such destruction is in fact achieved is not relevant to the establishment of the dolus specialis. The victim of a genocide must be part of a recognizable and definable group, joined by a common nationality or ethnicity or race or religion. The intent must be to destroy the group as such. That requirement was explained by this court in the Bosnia judgment, some of you will know very well, as underscoring that genocide requires an intent to destroy people who share a particular group identity because of who those people are, as the court said. The words as such emphasize that intent to destroy the protected group. In this regard, they are targeted not because of what they have actually done or might do, but simply because of who they are. That is what counts in genocide. And let's be clear, there's not a shred of doubt, none, that the Rohingya are a group within the meaning of the convention, and there is not a shred of doubt that they have been and that they continue to be to this day targeted as such. My colleague, Mr. Suleiman, is going to address the point later today. Alongside these requirements, the chapeau to Article 2 stipulates that the intent has to be to destroy the group in whole or in part. As the court's findings in respect of Srebrenica make plain, a targeted part of a group has to be a substantial part. But that does not mean that it has to be a numerically significant part in the context of the group overall, where other factors combine to make it substantial. As the court stated at paragraph 296 of the Bosnia judgment, substantiality is to be assessed by reference to three elements, namely quantitative factors, relevant geographic factors, and emblematic or qualitative factors. The evidence you're going to hear over the course of this week and next will leave no doubt that the targeted part of the Rohingya group was by reference to these three elements, and it was substantial. I turn next to the need to establish the presence of the dolus specialis. As the court has made clear, this can be either on the basis of direct or indirect and circumstantial evidence. In the Croatia judgment 10 years ago, the court clarified its approach to identifying the existence of dolus specialis. It said, and I quote, "In the absence of a state plan expressing the intent to commit genocide, it is necessary in the court's view to clarify the process whereby such an intent may be inferred from the individual conduct of perpetrators of the acts contemplated in Article 2. In its 2007 judgment, the court held that, and you'll see the words here on the screen, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent." End of quote. Now, those are words, no doubt, we're going to be coming back to. The court can proceed on the basis of overt, that is to say, written incriminating evidence of a general plan. But for understandable reasons, perpetrators have tended to avoid that approach. And so the court, very wisely, we say, has recognized, has affirmed, that it can proceed by reference to circumstantial evidence in two distinct situations. First, by reference to particular circumstances which are convincingly demonstrated, or second, by reference to a pattern of conduct which could only point to the existence of the special intent. In the context of this application, as the evidence on the court's record establishes and as will be addressed by my colleagues this week, there are particular circumstances which convincingly show that Myanmar and its state organs acted with genocidal intent against the Rohingya. And that is especially clear in the case of at least 3 individual villages: Minji, Chut Pid, and Mang Nu, the harrowing accounts of which will be presented to the court tomorrow morning. Just as in Srebrenica, in the Bosnia case, the particular circumstances of what happened in those 3 villages, the concerted violence and devastation, the disproportionate and utterly inhuman treatment of the Rohingya who lived there, the widespread sexual violence, and even the targeting of Rohingya children, present, we say, the inescapable conclusion that the crimes against the Rohingya who lived there were perpetrated with genocidal intent. To be clear, we say that those 3 villages also formed part of a pattern, a wider pattern of conduct, which extended to dozens of other locations in northern Rakhine state, and from which genocidal intent is the only inference that could reasonably be drawn from the acts in question. That does not mean, however, as I've already submitted, that in relation to a pattern of conduct, it has to be the only motive. What it means is that on the basis of the evidence before you as to that special intent, it would be unreasonable to conclude that an intent to destroy the group in whole or in part did not exist. And in this case, that test is plainly met. The pattern of conduct across the various locations identified in northern Rakhine is only explicable, we say, on a reasonable basis by the existence of a genocidal intent acted upon by Myanmar. When the court considers, as it must, all of the evidence taken together, the only reasonable conclusion to reach is that a genocidal intent permeated and informed Myanmar's myriad of state-led actions against the Rohingya. Now, we note that Myanmar, in its rejoinder, accepts and agrees that genocidal intent can operate alongside and simultaneous with other motives. The interveners also agree with that. Indeed, the court has itself recognized that certain acts performed without genocidal intent may nevertheless also assist in deducing the existence of a genocidal intent. For example, in the Croatia judgment, the court held that acts, and I quote, acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention and may be significant as indicative of the presence of a special intent inspiring those acts, end of quote. This makes it clear in our submission that both such intentions, ethnic cleansing and genocide, and maybe other crimes, may coexist. And in this regard, I refer you to the intervention of the Republic of Ireland and to Judge Bandari's helpful separate opinion in the Croatia case to explain the point. What this means is that for a pattern of conduct to point only to the existence of genocidal intent is not to say that it could point to such intent only. This is how Ireland has put it, and Ireland is, of course, a land of remarkable writers, thinking of James Joyce and Seamus Heaney and Colm Tóibín and Fintan O'Toole, writers who really know about the power of words. And their lawyers have done the same thing. This is how they put it. The human mind can, of course, accommodate and act upon more than one intention. And the same conduct could be intended to achieve two or more results, however attainable each may be. It follows that it is perfectly possible that a pattern of conduct upon examination could point to two separate intentions, only one of which is genocidal. This possibility was recognized by Judge Bandari in his separate opinion in the Croatia case, wherein warning against conflating punitive motive with genocidal intent, he noted that genocidal intent may exist simultaneously with other ulterior motives. This approach, which recognizes and takes account of the realities and complexities of human behavior, we might call it the human factor, and in particular its darkest acts of expression through violence and conflict, is messy and it's complex. But this approach has got to be the right one in the real world if the Convention is to have any practical utility or function. It is this precisely that informed Lemkin's approach, as you will see when you read chapter 9 of his book. He understood, writing in 1944, that the perpetrator's mind is often a concoction of messy, mixed, overlapping motives. And accommodating that human reality is a way in which the particular threshold imposed by the dolus specialis must reflect the actuality of how human beings are and why they act, individually and collectively through the state. What makes them, what makes us do terrible things to other people. While the Gambia recognizes that it's the attributed attention of Myanmar that matters in this case, and not that of each individual perpetrator on the ground that has to be established, it also cannot be overlooked that a state acts through people. The court, in seeking to determine whether genocidal intent is the only reasonable inference to be drawn from a pattern of conduct, is not, therefore, asked to determine whether genocidal intent existed in isolation or exclusively or only. Rather, it is required to ask itself whether the evidence before it as to circumstances and conduct are such that, irrespective of the existence of any other motive or motives that may have been identified or stated, and which will no doubt be present in most real-world cases, a genocidal intent also must have been present. Myanmar's assertion that in the conduct of the clearance operations targeting Rohingya villages, it was merely undertaking counter-terrorism operations, cannot, therefore, serve of itself to rebut the existence of a genocidal intent. It is perfectly possible for there to have been a counter-terror motive behind some of Myanmar's actions, but at the same time, in the course of those operations, a genocidal intent also existed and prevailed, and in some form propelled the actions that were taken. Indeed, as Judge Counsel Trindade recognized in the Croatia case, and I quote, "Genocide may be a means for achieving military objectives just as readily as military conflict may be a means for instigating a genocidal plan." End of quote. In establishing whether genocidal intent must have been present in the context of a pattern of conduct, the court helpfully indicated in the Croatia judgment some of the most important indicators of that intent. And I'll mention four. They are, first, and I quote, "the scale and allegedly systematic nature of the attack." End of quote. Second, the fact that those attacks are said to have caused casualties and damage far in excess of what was justified by military necessity. End of quote. Third, quote, "the specific targeting of members of the protected group." End of quote. And fourth, quote, "the nature, extent and degree of the injuries caused to the protected population." End of quote. In this case, the UN fact-finding mission, an independent body, has a key role, and its findings, we say, are authoritative. It has identified 7 indicators of genocidal intent, not in abstracto, but in the vast amount of evidence it has gathered in respect of Myanmar's actions towards the Rohingya. And they strongly correlate with the factors the court identified that I've just mentioned in the Croatia judgment in relation to patterns of conduct. So the UN FFM, entrusted with functions by the United Nations, concluded that genocidal intent to destroy a Rohingya people as such could be inferred in the following way. First, the Tatmadaws' extreme brutality in its attacks on the Rohingya. Second, the organized nature of the Tatmadaws' destruction. Third, the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operations. Fourth, the insulting, derogatory, racist and exclusionary utterances of Myanmar officials and others prior, during and after the clearance operations. Fifth, the existence of discriminatory plans and policies. Sixth, the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. And seventh, the state's failure to investigate and prosecute gross violations of international human rights law and serious violations of international humanitarian law, both as they were occurring and after they occurred. In due course, my colleagues are going to take you through a close consideration of these 7 indicators which emerge from the vast amount of evidence before you. And the Gambia invites this court to reach exactly the same conclusions that the FFM did, namely that the only reasonable conclusion is that Myanmar acted in this case with genocidal intent. Of course, the commission of genocide is not the only internationally wrongful act prohibited by the Convention. Article 1 also creates an obligation to prevent and to punish genocide, and Article 3 prohibits a range of acts ancillary to genocide, including, but not limited to, conspiracy and direct and public incitement to commit genocide. Whilst the Gambia's primary case is that Myanmar has committed genocide in violation of Article 1 of the Convention, violations of Articles 3 and of the duties to prevent and punish genocide also form part of our case in full. And these other punishable acts will be addressed by my colleague, Ms. Jones, later in the week. Before I conclude, a brief word about the evidence before the court in this case, and you're going to hear more about this, and the approach that we invite the court to take. The court itself has set out its task in general terms, in other cases, plainly. It is the duty of the court, after having given careful consideration to all the evidence in the record, to assess its probative value, to determine which facts must be considered relevant, and to draw conclusions from them as appropriate. The court will make its own determinations of the facts on the basis of the totality of the evidence presented to it, and it will then apply the relevant rules of international law to those facts which it has found to be established. And so it's for the court to consider whether in totality the evidence before you, in the case brought by the Gambia, stands up. There's no single type of evidence or method of proof that the court restricts parties to rely on. Evidence from any source can be taken into account, and it will be for the court to assess its credibility, reliability, and probative value to the issues in question. It is for the party alleging a fact to demonstrate its existence. But even this, in the court's practice, is not an absolute rule. As the court has said, the determination of the burden of proof is in reality dependent on the subject matter and the nature of the dispute brought before the court. It varies according to the type of facts which is necessary to establish for the purposes of the decision of the case. And so the court takes an inherently, and we say appropriately, flexible approach to the evidence it is prepared to receive and consider in order to ensure that it is equipped with the materials necessary to make its own determination of the facts and to apply to those facts the relevant rules of international law. Mr. Reichler is going to address this in detail. The Gambia's evidence, its reliability, and its probative value will be a matter for him. Suffice it to say at this early stage, the totality, the body of evidence presented by the Gambia on this application, fully underpinned, as it is, by the careful, thorough investigations of the UN FFM and the many eyewitness accounts that were collected by that body, is compelling and persuasive. To take the words of the court, it is convincing. It provides a strong foundation for the court to reach conclusions on the facts and to find that the Rohingya genocide is clearly established. Mr. President, members of the court, I've addressed the existing legal standards for proving genocide under the 1948 Convention in general terms, including proof of dolus specialis. These standards build directly on the approach set forth by Raphael Lemkin in his book, Axis Rule. And so I'm going to conclude by returning to where I began. New conceptions require new terms, Lemkin wrote in November 1944. He noted in these pages the evolution of international law having brought about a considerable interest in national groups, as distinguished from states and individuals. He invented the concept of genocide to deal with that evolution. And by genocide, he wrote, we mean the destruction of a nation or of an ethnic group. This occurred, he continued, as a composite of different acts of persecution or destruction. And on his interpretation, they occurred in two phases. One, these are his words, destruction of the national pattern of the oppressed group. The other, the imposition of the national pattern of the oppressor. And he continued, the oppressed who were the subject of genocidal acts could remain, or they could be removed. The oppressed were always members of certain national groups who lived as minorities. And I quote him, "If these groups should not be adequately protected, such lack of protection would result in international disturbances, especially in the form of disorganized emigration of the persecuted who would look for refuge elsewhere." End of quote. And against this background of what he saw between 1933 and 1945, he proposed, quote, "An international multilateral treaty should provide for the introduction of provisions protecting minority groups from oppression because of their nationhood, religion, or race." The 1948 Convention is that international multilateral treaty. And Lemkin's words, written in 1944, and Article 2 of the 1948 Convention capture, regrettably but exactly, what has happened to the Rohingya. Lemkin's assessment back in the 1940s was the product of a meticulous exercise of research and reflection. His book and the Convention are testament to the power of ideas, to their reduction into a written and legal form, and to their capacity to hope for the world as a better and safer place. Raphael Lemkin lived through terrible times, just as the Rohingya have. But at no point did he, or his colleague Hirsch Lauterpacht, or so many others like them, choose to curl up in a corner and weep, or conclude that action or international rules were pointless. And the Rohingya have adopted exactly the same approach. And so has the Gambia, whose Attorney General you heard from this morning. That is why the Gambia is here today. Mr. President, the Genocide Convention, including its Article 2, really matter. And so does its meaningful and effective interpretation and application on the facts of this case to the situation regarding the Rohingya. It's to that issue that Mr. Reichler will now turn, and perhaps, after a brief pause, you would call him to the bar. I thank you for your attention.
His Excellency